If you are in the U.S. unlawfully for more than 180 days, you could be barred from re-entry for 3 or 10 years from the date you left. This is known as a 3-10-year unlawful presence bar. Hi, my name is Dyan Williams and I'm an immigration attorney. In this video, I'll talk about unlawful presence and how you accrue it. There are two main ways you accrue unlawful presence in the U.S. Number one is an overstay. An overstay means you were lawfully admitted to the U.S. but then overstayed your authorized period. An example is a B2 visitor who comes into the U.S. with a 10-year visa but is given only 6 months of authorized stay. If that person remains beyond the 6 months, she begins to accrue unlawful presence on the day her stay expires. Now, there are some situations where a person is out of status but does not accrue unlawful presence. An example is an F1 student visa holder who is given duration of status. If the student drops out of school or works without authorization, she is out of status. But she does not begin to accrue unlawful presence until an immigration judge or USCIS actually finds that she violated her status. The second main way you accrue unlawful presence in the U.S. is to enter the country unlawfully without proper inspection. An example is if you sneak into the U.S. by foot through the border with Mexico without presenting yourself for inspection. Because you did not present yourself before Customs and Border Protection officer, you begin to accrue unlawful presence on the day you set foot in the U.S. There are at least two situations where, technically, you were lawfully admitted to the U.S., but you begin to accrue unlawful presence on the day you set foot in the U.S. Here's example number one. Let's say you lack a visa to enter the U.S., but you're able to come in to the U.S. by driving in a car with a U.S. citizen or permanent resident. If the Customs and Border Protection officer asks that person for their travel documents but doesn't ask you any questions and waves you through, you are lawfully admitted to the U.S. But you don't have any authorized stay, and you begin to accrue unlawful presence on the day you enter the U.S. Here's example number two. Let's say you lack a visa to enter the U.S., but you're able to come in by fraud or willful misrepresentation. An example is if you use a fake visa or someone else's passport to enter the U.S. If the customs officer lets you through on that travel document, technically you're lawfully admitted, but you have no authorized stay and you begin to accrue unlawful presence on the day you enter the U.S. There are three main exceptions to the 3-10-year unlawful presence bar. First, unlawful presence prior to April 1st, 1997 does not count towards the 3-10-year bar. This is when the law kicked in. Second, unlawful presence before you turned age 18 does not count towards the 3-10-year bar. Third, leaving the U.S. with advance parole does not trigger the 3-10-year bar. If the 3-10-year unlawful presence bar applies to you, you will need an immigrant I-601 or I-601A waiver to immigrate to the U.S. through the consulate. The waiver is hard to get. If you are already in the U.S. and can somehow apply for a green card through adjustment of status, this is usually the better path to take. That way, you avoid triggering the 3-10-year bar because you departed the U.S. for consular processing. If you do need to apply for an immigrant visa overseas at the consulate, you do have to determine whether to file an I-601 waiver application overseas after you've attended your visa interview or file an I-601A provisional waiver while you're still in the U.S. before you attend your visa interview. For more information on the Immigrant I-601 or I-601A waiver for unlawful presence, hop on over to my website and read my articles on my immigration blog or watch my other videos. If you need specific advice or guidance on the waiver application, call me or contact me through my website at dyanwilliamslaw.com.